You're listening to the Subrogation Support Network, a podcast from Mathieson, Wickert & Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everyone. This is Ashton Kirsch, your host with today's episode of the Subrogation Support Network podcast. Today, I have a partner with our law firm, Lee Wickert. It's great to say partner, right, Lee? Lee is one of our newer partners, one of my newer partners with the firm, and glad to have you on board over there.
Thanks, Ashton. Yeah, it means a lot.
So Lee's down in our Texas offices. I know, Lee, you joined me for a podcast not that long ago, right? What was our topic?
We talked about indemnity in releases and how subrogation adjusters should be dealing with that topic.
Okay, so this is going to be way more eventful than that, I think. This is that was a great topic, very important with the releases and so forth. But I mean, this downtime claims, I mean, it's really a fascinating issue, right? Especially for those in the industry who deal with commercial auto claims. Now, when it comes to downtime, loss of use, it kind of goes twofold, right? There's personal auto loss of use claims, right? That would be, the rental replacement vehicle when your Ford F-150 is in the shop. We're not really going to focus on that today, though it's, relatively related. More so what I want us to discuss today are going to be, commercial auto downtime loss of use. For those who aren't necessarily familiar with the industry, downtime is kind of just that, right? It's the idea of the time that vehicle is down and the associated damages in loss of use that can be claimed therefrom. So, we see this in many different forms in our claims. Interestingly, a very small minority of our clients actually have commercial auto downtime coverage where we're getting these claims from the client carrier. We do have other self-insured motor carriers or trucking companies, self-insured corporations who have their own downtime claims. So they have these cases and claims associated with the loss. And then plenty more where we're actually coming in and we're helping our insured as a service to the insured at the request of our clients to pursue these cases. But all in all, I mean, it's something that's moving forward very rapidly and changing in the industry. I can tell you that about 5 years ago, when I was making downtime loss of use demands, adverse liability adjusters, they looked at these things and most of the times they wouldn't even respond or they just straight out deny it. I think that in the industry, downtime and loss of use is gaining weight, right? There's more merit. And it's kind of been at my, I've been pushing really, really hard on these claims, and it's made a difference that we've been pushing harder because most liability adjusters are taking these claims seriously now. Now, are you seeing the same thing on your end, Lee, or what are you seeing over there?
Yeah, absolutely. I think the downtime claims is something foundational to tort law. It's a part of your damages. It's, when you're a victim of a car accident, you want to be placed in the position you were exactly prior to when that car accident occurred. Now, when we hear that, we think, okay, pay for my to straighten out my bumper, get my windshield repaired, and if I'm hurt, reimburse me for those medical damages. Those are concrete things we think of. We don't often think of this downtime, this loss of use, the time we were deprived of our vehicle while it was being repaired or replaced. Those are damages. You need to be compensated for that time you were without your vehicle. I mean, you mentioned we're going to kind of skip over the personal auto, and I don't want to discourage any adjusters out there that handle a lot of personal auto. Loss of use is a very viable claim on the personal side of things. It's just a lot simpler. So this podcast is going to focus more on the commercial side because that's a more complex beast. But the things you'll learn while dealing with commercial certainly also apply to personal and should be asserted, the downtime for personal. Yeah, so I'm seeing it. Go ahead.
These downtime claims, I mean, they can be viable in and of themselves, right? These are cases we can make, but also we can use them as useful negotiations tools. So we're going to talk about that, leverage we can create, what ways we can look at these things to make it more practical to pursue. And also, I think it's important to note when we get these cases, there's going to be a lot of pitfalls, right? When we're viewing these from a practical level, in that a lot of times when we have let's use the example of ABC Insurance Company writes commercial auto policies. They have a $35,000 auto collision claim, right? Property damage. They make a demand, but they're insured. They were out 3 months because their tractor was being repaired. Well, at that point in time, that insured has an uninsured downtime claim, right? They have the time that they were down. Sometimes they can get another vehicle up and running immediately. Sometimes it's 2 weeks after. Sometimes it's a day after. Sometimes these smaller trucking companies, and we'll talk about COVID and the impact on that, but sometimes they can't get a vehicle or a truck or tractor until 3 months later. So we're sitting there looking and analyzing and assessing these things. And there's kind of some practical considerations that we as attorneys need to consider where, I'll give you an example, Lee, of what I do is when I have a client that sends me a case and they say, hey, contact our insured, discuss their downtime claim because we'd love to, as a service to them, allow you to pursue those damages should you be comfortable in doing so. So this would be one of those situations where my clients will oftentimes give me the choice on whether or not to pursue it. And at that point in time, we just pick up the phone and we have that call. And I can tell you that, a lot of times, a lot of these small owner operators, I mean, these individuals, they don't necessarily know everything about the law, right? They know trucks, they know transportation, they don't know how claims work, right? So when we go to them and tell them, hey, there's a reasonableness standard, or you're going to get a portion of your damages back, but expecting 100%, highly unlikely, right? We have those conversations, and oftentimes we'll hear back, oh, of course, I just want to get something to compensate me. I'll be happy with 75% of what I'm asking for. It's down for 2 months, and if I can get a month and a half is reasonable, perfect. But then sometimes we'll also get that trucker who, their vehicle was down for 3 months for repairs, but then they never got it repaired for one or another reason. It's 2 years later, and they claim, oh, I'm out $400,000, and I expect to litigate this, and I expect $400,000 back and attorney's fees. Well, at that point, I can tell you we're not interested in that case. So it is really a unique thing when we're dealing with downtime because we get to really communicate and deal with the insureds, the truckers in more of a unique way than we typically would just in an auto subro case, right?
Yeah, and this is kind of where this topic gets fun is because you see this term pop up, and it's one of lawyers' favorite words, reasonableness. It makes things gray. What is reasonable? What is not reasonable? And the requirement to meet that reasonableness standard usually comes, it's companioned with a high evidence bar. You need substantial evidence to support that loss of use claim. And if you get that trucker with that $400,000 with lost profits, he's going to need to back that up. He's going to need to show that it was reasonable, that he mitigated his damages. And these are all things we'll get on to later about how to properly support your loss of use claim, your lost profits claim, and what evidence is required to do so.
And nothing is ever simple, Lee, right? And that's why we have so many resources on our firm's website, because one of the more unique things about loss of use and downtime are the state-by-state variants, right? But for the state-by-state variants, we could just wrap up this podcast now and be like, hey, you now know downtime, loss of use. Let's move on to the next one. But what becomes fascinating here is the fact that every state kind of has different rules. And we actually, interestingly enough, Lee and I built a chart on this. We have a 50-state survey with all the different rules on loss of use. Well, not all, but the important ones to us. Chart that includes the following questions, which we'll discuss. I want to discuss with you, Lee. Question 1, just is loss of use in general going to be recoverable? Okay. If loss of use is recoverable, is it recoverable for the rental costs of a replacement vehicle? Or can we actually get to lost profits, which frankly can be a huge difference, right? It can be, 10x in some situations. What evidentiary burden, you just discussed that, will you have to have in proving lost profits? Next question that we have in that chart is, can you seek loss of use damages for a total loss? Can you seek loss of use damage if a replacement vehicle is not obtained, right? Those are all important questions, and every state kind of is a different variant. Lee, give us some examples of those variants that you found while doing the research for this chart and while also kind of just handling these cases in general.
Yeah, absolutely. And if you know MWL, you know MWL charts. We love our charts, and this is a perfect topic to put on a chart. I got to go through, create it, and learn a lot about the different states and how they enforce it. The first thing I'll say generally is states are they do enforce loss of use. They do allow the recovery of loss of use damages. Uh, Overall, that seems to be the trend. Now, it becomes a lot closer when you look at lost profits. Most states, I won't say 50-50, but it's closer to that, which whether they allow the recovery of lost profits or not. Some states just say, hey, loss of use is enough. So I've picked out a handful of states here, and I'm going to start with my favorite state,
Now, Lee,
the state of Texas.
before we do that, let's quickly, just for the audience, because you and I both know what lost profits means. I'm assuming most listening here do understand, but just to make clear, when we talk lost profits, what we're talking about is it's the difference between what kind of damages we're claiming, right? Typically, it's really easy to show what the cost of a replacement vehicle could be. But the issue is for these trucking companies, for these commercial carriers, oftentimes just a replacement vehicle doesn't cover what they're actually out. Because when that vehicle's out of service, they're losing out on profit. They're losing out on their business, right? Their whole business is having that tractor to drive. So ultimately, lost profits would be just that. Downtime is just that. It's the idea of how much in profit they're losing when that vehicle's down. So we're actually talking about more than just the cost of replacement, but the actual loss that they are suffering when their vehicle is out of service. Lee, continue.
Yeah, no, I'm glad you stopped me. Often I'm very comfortable with these topics and I forget that others may not be. So thank you for doing so. Yeah, I wanted to start with the state of Texas. And the reason I start there is because they seem to be one of the strongest states which allow both loss of use and lost profits. Not only do they answer the question with yes, you can recover both, they go into more of the details of, okay, well, how do you establish loss of use? What is required? In order for a plaintiff to establish loss of use, they look at the reasonable rental value of a substitute car that's similar to the car that you lost. So it's very simple to calculate. You go look, okay, at the time of this accident, I go on to Hertz or Enterprise, I find a similar car. My car was in the shop for 14 days, and there it is. 14 days times the cost of a rental for one day, and there's your loss of use value. Now, for all of these states, we'll ask the question, okay, well, what if you didn't go out and rent that car during the time it was being repaired for those 14 days? Are you still entitled to those loss of use damages? And the state of Texas says, yes, it's not required to go out and seek a replacement vehicle. So that's a question you'll see come up quite a bit when handling different state-to-state cases. Okay, well, did your insured actually go out and rent a vehicle? Well, in Texas, it doesn't matter. We could have, but we didn't. But those are still part of our damages. A different state-to-state issue that comes up is, okay, what if your car wasn't repairable? What if it was a total loss and there no amount of days would have put you in a better situation than if you just went out and bought a new car? Well, again, state by state, this topic is handled differently in every state. In Texas, it does allow loss of use in total destruction cases. It does not care. Almost every state will have this caveat, though, is those loss of use damages must be reasonable. So you can't just, oh, I've been 6 months without my car. Texas allowed me loss of use of a rental value for 6 months. No, courts will strike that down. I know there's a Toyota 4Runner case out there. He claimed, I think it was 8 months worth of loss of use damages, $140,000 worth of loss of use. And he had all the paperwork to support it. It was all there. The court struck it down. That's not reasonable. No, you either needed to get that car repaired in an expedient manner or get it replaced.
Similar to to jump in with that is the idea with that replacement is there's also a like, kind, and quality dispute, which, every state's different on. It's the idea of what is a replacement vehicle, right? I had a case, a couple of years ago, I was out in California, where it was an individual who had some Kia Sorento or whatever the vehicle was, where they claimed that, oh yeah, to get this key, I want this specific same exact make, model, year package. And with all of that, it would have cost me $800 a day because I'd have to go get it. from, 3 states over, and they'd have to bring it in. And that's what I deserve. I deserve that for the 6 months. At which time we had to go back and be like, no, I mean, that's not how, that's not how we quantify it. It's not the exact same vehicle.
Hmm.
It's like, kind, and quality. There's a reasonableness standard, but ultimately that's a big thing. There's also specialized vehicles. I have a really interesting one that I recently handled where, it was a specialized HVAC truck where the job was there was a pipe bender and Peter Jack and all kinds of stuff in the back of this customized vehicle. And it was damaged. We claimed loss of use, and it was about $400,000 in loss of use damages because it took 6 months for them to refab a new truck that worked the same way. Well, guess what? In that situation, we were fully able to justify it. We were able to recover the full damage amount because it was unique enough to show of like, kind, and quality. Well, it needs to have all these things to do the jobs that it's supposed to do. But in most situations, you're right. There's a reasonableness standard, a duty to mitigate, and it shouldn't take that long to just get a normal, be it midsize SUV or sedan for somebody up and running. But
Hmm.
that's on the passenger side,
Well,
or through Ryder, a Peterbilt, or whatever it could be to help them transport cargo.
yeah, that topic comes up a lot in the commercial realm. The different trucking requirements, if it needs a reefer, different types of plows. Often you just can't find a replacement, and so those specific requirements, if your insured's claiming that, that should be detailed, that should be documented, and then submitted to that third party to explain this is a specialized piece of equipment. We can't just go and order any old tractor trailer that won't do the job required to put us in a similar position. So I handle a lot of municipality cases for different uh, police offices around Texas. A lot of drunk drivers into cop cars. Cop cars drive the Chevy Tahoes, but that's no ordinary Chevy Tahoe. That's a very specialized piece of equipment with specialized gear, bulletproof glass. I mean, I don't know of any websites you can just go lease a Chevy police cruiser, but that allows us to submit these loss of use damages, which are more specialized and they're not as questioned. But I'm tasked with presenting that information to the third party and explaining our position to great success, I must add.
Yeah, I
Um,
see that all the time with ambulances, other vehicles where sure there's or let's say the fire trucks where they're driving a GMC, right? To
mhm.
accompany the fire truck where, there's sirens, there's lights, there's safety equipment, there's all this stuff. And next point, liability adjusters, well, here's their, look, you could have rented a, full-size SUV for this much. Like, hold up, no, this is a specialized vehicle. You can't just put this out on the road without the correct paint, lights, and so forth. And that always becomes a dispute, but something easier to overcome. But to stay out of the weeds there, let's get back to what you're talking about. You're kind of going through some of these variants here before I interrupted you with the unique nature of these vehicles. But Lee, go back. Tell us what you're thinking.
Yeah, this is great. And so I started with Texas, very strong state for loss of use. And I wanted to point out one other very strong state, and actually one that surprised me is California. California has very strong laws that protect a plaintiff's ability to bring loss of use. Um, you know, Loss of use is calculated by the rental value. The substitute vehicle doesn't actually have to be rented, and loss of use is still recoverable even in total loss situations. Lost profits are also allowed. Now, not quite as strong as in Texas. Lost profits are allowed, but courts are very careful to grant lost profits, and they try to avoid situations in which plaintiff is receiving a double recovery. So they're more stringent about evidence, what is required on that. Um, if there's if full profits are recovered, the courts will then not allow the recovery of loss of use. So there's kind of an interesting interplay of loss of use and lost profits. If you can show that full profits have not been recovered in California, then you can make claims for loss of use for that replacement rental value. So I thought California was interesting, still a very strong state, but has some different caveats. Kind of coming down the ladder, moving to states with not as strong of loss of use rights, takes us to New York. Now, New York is still a strong state. It still allows loss of use. It's going to require you to show fair market rental value of that property, but it's not going to allow you to recover loss of use when that vehicle is a total loss. So when you can't repair your vehicle, they're not going to allow that loss of use. Um, Loss of use can be recovered when there is no substitute vehicle actually rented. So they're still strong there. You don't have to go out and rent the vehicle, but while your car is in the shop being repaired, loss of use can be recovered. But when it's a total loss, no loss of use in New York. Where New York gets a little more interesting is on the lost profit side. So lost profits is technically allowed in New York, but there is a much higher bar. They kind of look at lost profits more under higher scrutiny. They're more considered speculative in nature. So the evidence required to bring a lost profits claim in New York is much higher. Evidence that would pass muster in Texas may not pass muster in New York. And there's even a split in authority amongst the appellate divisions out there in New York on whether lost profits can be recovered at all. And the topic comes down to, and this is something you'll see quite a bit on the commercial side, is if you've got a commercial a commercial trucking company, and they've got a fleet of vehicles. Let's say they've got 10 vehicles, and vehicle number 10 gets an accident and is out of commission for a month. New York will require you to prove that those other 9 vehicles were in full use and cannot be used to cover the duties of that 10th vehicle. So that's something to keep in mind is substitute vehicles within your own commercial fleet. If you can show that, hey, look, I had no other vehicles to cover the duties of this 10th truck that I lost, you can be entitled to lost profits. But if you have 3 trucks sitting idle that easily could have taken over the duties of that 10th truck, courts are going to strike that down and not allow you to recover lost profits.
And that's a huge thing to mention. And actually, I wish more liability adjusters had, taken a course on that, because a lot of times you'll hear them pushing back when we're just asking for like the value of a rental vehicle. They'll come back and say, well, look, this motor carrier had all these other vehicles available. They can't suffer loss of use. And by the way, that's blatantly false. It's not true. In almost every state and jurisdiction, just because they had other vehicles available doesn't mean that they didn't suffer a viable claim for loss of use and that they can't make a claim for the damages. However, like you said, Lee, in New York and some other states where the burden is really high to get to that lost profits, right? That lost profits downtime claim, then yeah, that is one of those things to show that there's no substantially similar vehicle available in their fleet. And that makes it really hard for large motor carriers, the big named companies of the world out there to make those claims, right? So, and I think that the big thing on those that at least I've experienced, Lee, and I'll mention, is that that's one thing that they push back on in those states when we're claiming lost profit downtime. But the other thing that they always come up with is how it's calculated. So for all my clients, we all have different downtime calculation forms. Pretty much it's a document, typically a one sheet that we provide to the owner operator, to the owner of that company, showing, here's your weekly revenue, gross revenue. Here's, your expenses. We cut out those expenses that are, non-variable. We look at obviously, you're saving on gas, right? You still have to pay your insurance. Maybe you still have these other things. So just distinguishing between static and actually variable costs that can be saved in not operating the vehicle. And then we come down to like a daily loss of use number, right? So when we have that, then we can come up with like that hypothetical. And usually it's based on either 3 months, 6 months, or a year, right? A lot of times, obviously, the further out you get, the better. If you can use, if it's similar years, getting a similar date range, if it's seasonal work is helpful. So that all depends on how you do it. But, I think one big thing that Lee had mentioned about New York and those states that have a higher burden is I've seen some states where we can't even rely fully on past earnings. They're now requiring not hypothetical profit, but they're saying, what were your actual booked loads, right? What loads did you actually lose out on? Which is really, really hard, if not impossible to prove, because many of these smaller trucking companies, the way they operate is they're picking up these loads from a broker's board, and they're picking them up, a few days before, the week before. And it's not always that that they know a month, 2 months before what their profit would be in future months. So that's all I have on that. Lee, continue.
Yeah, and as you're probably picking up, the bar to lost profits is much higher than loss of use. In order to calculate it, I can't name any state that has set out specific ways to calculate lost profits. What they've said is just a different bar, a different level of scrutiny. Some states have a high bar, must be beyond reasonable. Calculating lost profits, like you mentioned, is a great way. The more specific, the more documented, the more evidence you have to support that lost profits claim, the more successful you'll be in order to recover them. Just know lost profits is going to take more information in order to be successful than that loss of use. I've got two more states I've picked out. The next one is pretty interesting, and it's Iowa. Iowa's interesting because it's one of the few states that doesn't allow the reasonable rental value to be calculated for that loss of use damage. They specifically state that it's not generally accepted to determine the measure of loss of use, but they don't really say what is. Here, I'll read verbatim what they've kind of explained when calculating loss of use. So this is talking about damage to a vehicle when it can be repaired, and it will be, when it is repaired, is in a as good or better condition than prior to the accident. To measure that loss of use damage, it's the reasonable cost of repair plus the reasonable value of the use of the vehicle for the time reasonably required to complete its repair. Now, how do you calculate the value of the use of the vehicle if it's not the reasonable rental value? I'm not quite sure, and I think that's something that it needs to be proven and shown by the plaintiff in order to calculate that loss of use damage. So Iowa is one state that seems to kind of scrutinize the use of rental value, so that's something to be careful for when bringing loss of use damages in Iowa. Now, Iowa, for lost profits, there is no case law which specifically addresses the lost profits, but they have case law has said that the calculation for loss of use is more encouraged than bringing claims for lost profits. So Iowa case law seems to encourage the use of loss of use and discourage pursuing lost profits. So we're starting to see kind of more scrutiny on this loss of use and certainly on the lost profits side. And the final state I've picked out is a significant state. It's the state of Florida. And the reason I picked this and saved it for last is because their answer to the question, can you recover lost profits, is a flat no, period. There is no way for you to bring lost profits in Florida. The courts have specifically state that profits is an alleged loss. It's a concept subject to too many variables to be properly used, and they only allow loss of use in the state of Florida. Now, the loss of use laws are stronger, especially when compared to Iowa. You use the reasonable rental value of the substitute vehicle, and that's regardless of whether that rental vehicle was actually obtained or not. So also in Florida, I should note that it does not matter if it's a total loss. Loss of use is recoverable, but they're one of the few states that just say no on the lost profits.
So it's those
important.
These few examples that are so varied. I mean, that's really why we built this chart. It was kind of largely just to help our clients and even help the adverse parties who we were trying to negotiate these things with, to be honest. Allow everyone just to have somewhere to start from, because it's really unique in that a lot of these issues, frankly, downtime, loss of use claims, lost profits, there's not much case law on many of these things because it's like diminution in value, right? People are pushing these cases left and right, but most of them aren't large enough to justify the extensive litigation that could get to the point of a written opinion and a decision on the issue. So that's why we really don't see much case law. So, I mean, this chart is hugely impactful, but yeah, there's a lot of variance, and Lee, those are some really good examples.
Yeah, and being equipped with the chart is step number one. Knowing the law of the state you're in will help arm you in, arguing with a third party adjuster, debating whether you can bring loss of use, whether lost profits are appropriate, and if they're well documented. I mean, the major takeaways is loss of use, downtime claims, they must be reasonable. You can't get around that reasonableness standard. Every state's got it. I mean, that's just 101 to tort law. Your damages have to be reasonable. Um, ensure that your insured is mitigating their damages. If their vehicle is damaged, make sure they're getting it repaired in a timely manner, making sure those repairs are getting done as quickly as possible. Finding a reasonable rental car can help, reduce their loss of use and get them into a car to mitigate their own personal damages.
And mitigation is usually where I get pushback on. I think that if there's one thing when I have viable loss of use claims, where I make the demand, adverse adjuster comes back, usually they're negotiating. Sometimes obviously we'll get pushback on the total amount and they'll look at but my downtime calculation forms are pretty straightforward, right? My lost profit forms. So usually, there's not much to argue there. So what they're arguing instead is they're arguing the reasonableness for the amount of time that vehicle was down. We're saying, yeah, the repairs took about 2.5 months, so we should be subject to 2.5 months of loss of use. At which point it's based on the days in operation. So you look at how many days that vehicle was operating. On those calculation forms, usually it's based on a daily. So you say it was operating 15 days during that month, times 2, times 0.5, giving you a certain amount of days to get that number. Oftentimes when they come back, they're not as often arguing what the daily rate should be, but they're more so saying, oh, that's ridiculous. It doesn't take 2.5 months to repair, a windshield or whatever it could be. And usually that's where it comes down to. It's working with the repair shops, getting all the information we need to show the reasonable nature, and that our insured did everything that they could to get the vehicle repaired in a reasonable period of time and mitigate all damages. This got way more interestingly when COVID came around. And I want to
Exactly.
mention that, right? Because COVID had a huge impact on downtime. Because with the supply chain issues, we had clients, their insureds who had their vehicles in the shop waiting for a random part that typically would be just held in the stock, but now they're waiting 5 months. What happens there, right? And that ended up being a huge fight. Lee, any insight on that?
Well, it's interesting because, COVID is thankfully a thing of the past, but I still have cases that took place in, 2021, early 2022. They're still in my docket, my caseload. And so when I go to submit demands for these cases that happened 2 years ago, I'm submitting a loss of use claim from the COVID era, from a time of shortage, from a time of work chain supply shortfalls. And they're saying, well, this is ridiculous. Here's the value of a rental car. And they punch it into Hertz, and that's a 2024 rental value. I'm like, well, we're not talking about 2024. We're talking about, middle of COVID, 2021. And the numbers are way higher because they were at the time. And so it's been a very interesting uh, thing to argue with adjusters because they have to go, put themselves back into the shoes of someone in 2021 and the hardship it would be to go find a rental car. I mean, I think most of us have kind of forgotten that there was a car shortage. You can even buy used cars, and the price of used cars skyrocketed just because of the short supply of vehicles. So hopefully a very unique moment in history for downtime claims and not something we'll have to deal with in the future.
In commercial auto was even worse. I had one recently that during COVID time frame, it was a loss in Alabama, kind of outstate. They went to Penske, they went everywhere, and they're just trying to find a tractor that they could use to pull the trailer and to get their job done. And they had told me, like, Ashton, we tried everywhere. We couldn't find anything. We then eventually, 3 weeks later, finally were able to set something up with a rental company out of Georgia. We had to drive there, and we had to pay, what would typically be, I don't remember the numbers, but let's say it would typically be $400 a day. We had to pay about $900 a day, which would still be saving us money because now we could actually operate. But we're paying $900 a day for, the 2.5 months until it was up to operate in operation. We reviewed it. We did our due diligence. We called the local, and we actually had to speak to the local dealerships or the companies that rent these tractors, and they confirm, no, like, yeah, we had nothing available. That's true. We were able to get an affidavit of that, and we were able to prove up that, yeah, the most reasonable option that could have been taken was just that, was going to Georgia, get another vehicle, paying 2 to 3 times what it typically would have been pre-COVID to get that rental replacement tractor so they can be in operation. And at first, the adverse just pushed back and said, absolutely not. We don't know for that. And I was able to provide the requisite legal argument showing, no, you owe for, loss of use for the time that it's down and for what it would cost to have a reasonable replacement vehicle. I mean,
Yeah.
and we were able to do it, but it's it definitely gets interesting and creates an added dynamic or layer to these cases.
Yeah, and you keep seeing that, hearing that word reasonable. As long as you're acting reasonable and as long as you have the evidence and documentation to support that you acted reasonable. I mean, that's how we're able to, come out on top with these COVID claims is to show that we took the necessary steps to act reasonable and try to mitigate our damages in that time.
Yeah, and we also see from a similar side would be we get quite a few cases, those unreasonable ones, which frankly I won't touch with a 10-foot pole, but it'd be those cases where the driver says, well, I'm not made of money. My truck was damaged. I couldn't afford to get it back operational. I've been down for 3 years. That's what I should be owed. That's what, and it's coming down with that perspective. And I've gone through that before, and I've had some cases. 98% of them, right? That's an assumption. Are there's some way for them to get a rental replacement, right? They just either wanted to stop operating or they didn't want to do the work to get something else up and running, right? Frankly, most of the time we look into it and realize that they did get another vehicle and they're just not being forthright. But other times I have actually found that in very unique situations, we have been able to show that for an extended period of time, it's never been like 3 years, but I've had 6 to 8 months where there was something with this being a very small company and they're not having we were able to prove that they had no financial capacity or capability of getting a rental replacement vehicle. And there were delays in the repairs and so forth, and that it was reasonable. And we were able to recover a higher dollar value. So, I mean, I guess it's really important to note that there's no way to point this with with broad strokes. I mean, it's case by case. We need to review each case specifically because, not just the facts of the case, the facts and background of the insured, but also the jurisdiction. I mean, it all comes into play on these downtime claims.
Yeah, absolutely. I mean, this is where the chart comes in. We're getting your subrogation counsel involved is a major step. And including those loss use damages in a demand is a great negotiation tactic because, if they're not well documented, then I think it's easier to part ways with that demand. And then you're already giving up something and maybe they offer you 100% of the property damage, but say, okay, no on the loss of use. I mean, that's a major win, and you really didn't give up much anything.
Yeah, for those self-insured clients or those clients who have that coverage, that's a huge option, right? I know that honestly, I represent a decent number of very large and small self-insured trucking companies around the country. And I'd say when I first started working with them, very few of these motor carriers, these big trucking companies, very sophisticated, but very few of them were actually pursuing their downtime claims, their loss of use. They just figured, hey, one person told me once, well, somebody once told us that because we have so many vehicles, we just don't get loss of use, so we just never pursued. And I'm like, nope, hold up. That's not true. So I just want to enunciate that to anybody listening to this podcast who works for a self-insured or somehow has these claims, pursue them, either independently of themselves. I mean, even if they're not huge, right? These damages are independently of merit. They have weight. You can bring in money on them. That being said, they also can be used as a negotiation tool. If you have a $2,000 downtime claim, why not ask for it, right? A $20,000 downtime claim, of course, ask for it. Use it as independently to get that money back, or even just if you're having trouble proving it up, use it as leverage to negotiate a better deal on the PD end or whatever end it is. So I just think that's the important thing to notice. There is a lot of weight and merit to these things, and nobody, even though I know they are, should be just letting them lie and not pursuing downtime loss of use damages.
Absolutely. That's what we're here to share the good news.
Sure are. So Lee, anything else to share on your end?
No, that's it. Thanks for having me, Ashton. It's been a pleasure on this podcast once again.
Beautiful. Everything good down in there in Texas for you?
Yeah, I'd say today is the first day of spring. I started seeing wildflowers. It's been a long, cold winter. I think we've had 5 weeks of winter, so we're
5 weeks winter. I'm in Wisconsin. We have 5 months of winter, if not more. And I see no wildflowers. I see snow. See more snow, gloom, but that's all right. It's we just had our 10-year anniversary for the New Orleans branch, which if you listened to our last podcast, my partner Jim Busenlener joined me and we talked about our New Orleans office, and I got to go down and visit the beautiful city of New Orleans, and that was nice to defrost a little bit. I'll tell you that.
absolutely.
Well, all right. Thanks, Lee. I appreciate it. Thank you to the audience. As always, a pleasure. This is Ashton Kirsch, your host with the Subrogation Support Network podcast. Thank you for joining us. Have a great day.